that those things should happen after his death or when he is no more, because the written declaration of his intention as to what should happen when he's no more, it qualifies to be a will. And we'll get to understand that it is not a legal document. So you can actually take a pen and paper and write your own will right now, just after listening to me. Except that if you want it to be properly written and you want to comply with some few provisions here and there, you might just have to get a lawyer to assist you. But from the very beginning, we need to understand that it's a written declaration of intention. Okay. We'll just keep that definition in mind as we go along. It can be a little more complex than that, but I'm not doing this so that you become a lawyer, so that you just get a license. So I don't need to bore you with all the very detailed information about it. So every written declaration of intention, which relate to things that will happen after your death, qualified to be a will or your will. The lawyer will call it your last will and testament. So in the course of this presentation, you'll be hearing some of these words, and I think I should briefly explain them to you so that when you hear them, you don't get confused. You'll hear the word testator, and testator is the person who makes a will. So if you made a will, you are a testator. And a person who you have appointed in the will to receive a benefit is called a beneficiary. A beneficiary. So if I have decided that in my will, I will give my house at so and so place to my daughter, to my son, to my wife, to my mother, to my friend, or to some cousin of mine. Those wife, children, cousins are beneficiaries. Okay. And then a will is often a written document, as I said. So when it is written and signed by the testator, it has to be witnessed. So there'll be witnesses as you'll hear. And then we also have what we call executors. Executors are people appointed to carry out the instructions or the wishes of the deceased person in his will. So whatever wishes or desire he has written down in his will, the people who implement it, if he says that give my car to so and so person or give my land to this person, the ones who ensure that the wishes are carried out when you are no more is an executor. So that is what you need to know. I mean, you'll hear the word last will and testament as I've already mentioned. It's just the same as a will. It's a very simple term. I mean, and you also hear about the reading of a will. When a person dies, there must be you must properly write to the court to find out if there's a will in the court. If there is a will, you get a copy. The court will summon family members to come and they'll read the or probate certificate. That is what authorizes the executors to start to distribute. That is very important. The properties. You also hear the word estate. Of course, you understand estate already. We're talking about all the things a person left behind after his death are his estate. So all your cars, your house, your shed, your furniture that you left behind after you are dead qualifies to be your estate, including money and all of that. You also hear about the word tested, and tested here, we're talking about someone who dies leaving behind a will. So if you die leaving behind a will, you die tested. But if you die without leaving a will, then we say that you die intestate. Okay. So now that we know what a will is and we appreciate some of the key terms that are often talked about or we'll be talking about in this presentation, let's understand what is usually included in a will. Um, think about making a will, just have in mind that you will ordinarily include clauses that will do two main things. The first one is that there'll be provision in the will to dispose of the properties you have acquired while you were alive. So all the cars, the furnitures, the phone, the laptop, your Facebook page, any property of available that you've acquired while you're alive, you can dispose of it. You can transfer it to another person, and that transfer will take effect after your death. And you do the transfer in your will. So that's one of the things you will see included in the will: clauses that are disposing or transferring or giving a property that you have personally acquired while you were alive. And then you will also find out that the will will have clause specific matters upon death. So you could say that I direct my executors to pay all my just debts. So your debts could be paid for by executors as a matter that can take place after your death. And you can also say that I direct my executors to appoint guardian for my 5-year-old child when I am dead. You can also do that too, so that that guardian will take care of the child when you are no more. This issue. So two things that you can do, including a will, is disposition of properties and any other matter you wish to talk about in a way. You can say that when I die, don't my body. Keep my body with University of Ghana Medical Center for medical purposes. You can say that it's permitted. Anything at all you want to happen after you are dead, you put it in your will. Okay, so um, let's talk a little more about disposal of properties. When we talk about disposal of properties, uh, first of all, there are two basic things that we need to look at when we're talking about disposing or transfer properties by your will. First thing is who actually can dispose of properties by a will. Is anybody who can do that? Or there are certain people who can do it? Is only the rich or the poor? Must you necessarily have landed property before you can make a will to dispose of properties by a will? We'll get to learn about that briefly. Then I think the next thing we should also know about is whether um, any kind of property can be disposed of under a will. Are there specific properties that you can only dispose of by will? So we'll talk about that. Now, when we talk about disposing of properties by will, not everybody can actually do so. Uh, the law requires that if you want to dispose of properties by will, then it should be a person who is at least 18 years of age and you own the property you want to dispose of. In other words, you cannot dispose of somebody else's property. So you have to at least have some properties. And everybody, I think, who is above 18 years have some properties. Um, if you step out one day, you have clothes on you, you have property you can put in your will. So property here doesn't always have to be landed property. So you must be at least 18 years and you must also have property. Uh, that's not all. You must also be of a sound mind. You must not be having any mental issue at all. That will prevent you from making the will of your own volition. Of that will prevent you from making a will as you personally desire. So you must be of a sound mind. If you are not so well, you are insane, or you have some mental issues, any will you made would be considered void because you don't have the mental capacity to make such a decision. Of course, there are exceptions about the age requirement when we talk about being 18 years. There are people who can be less than 18 years and can make a will. And the law often talks about the members of the armed forces. And armed forces here, we are talking about those who are in the Navy, the Army, and the Air Force. I mean, by the nature of their job, um, they are permitted to make a will even when they are not 18 years. But the question truly is whether people are uh, below 18 years and are in the Army, the Navy, and the Air Force. So that is, I mean, for another discussion. So, I mean, once you are 18 years and above, you qualify to make a will. Of course, you must be of sound mind, as I said. So all of us on this call, I believe, we probably are 18 years and above. So we all qualify to make a will. And I believe we own properties as well. If you are speaking or you join this particular meeting with a phone, I mean, you can make a will and give that phone to someone. Um, you may be saying that, well, this phone is not the very best and I may not own it for so long. So the truth of the matter is that you may not own it for so long, but I don't know how long you're going to live. Yeah, that is oftentimes um, what the law contemplates. That is where the provision is made that you can make a will anytime, change it anytime, make it again, and all of that. Okay, so having explained uh, a bit about the persons who can make a will, let's talk about what properties you can dispose. You can dispose of by will, and with properties here, we are talking about your own properties, self-acquired properties. So you yourself, you have acquired it, then you can put it in your will. not that you have, you know, obtained it with a group of people, or it's for your husband or your wife or your family, then you want to put it in your will. No, you can't do that. So say for self-acquired properties only. And then we also have properties that um, individual will be entitled to at the time of their death. So I will explain this a little more. And then we also have properties that you'll be entitled to after your death. So these are two different things. At the time you die, you will be entitled to it. And after you are dead, you'll be entitled to it. So let's talk a little about this self-acquired property. We're talking about these are properties that is owned by you, and you have acquired it by your independent efforts. Um, and then you have acquired it, and you have the power to give it to another person in your own name. You have the power to give to another person in your own name. So you acquire it yourself with your own resources. I mean, you might work any income and use it to acquire it. You could probably take a loan to acquire it. But sometimes if you take a loan to acquire it, if you are still paying the loan, chances are that the creditor has some interest in it until the loan is fully paid. So that one too is not so certain that you can give it out. But there's always a timeline for when the loan can be fully paid. So depending on that. But the important consideration is that that property in question you have personally worked and acquired it. Includes movable, immovable, and tangible and tangible property. So, like I said, we could talk about some common examples that land. I mean, no matter the plot, the acre, it can be part of your will. And house land here includes house or building, as we is anything fixed onto the land beneath it, and anything up all the way to the sky that qualifies to be the land. If you have a you have chairs, furniture, you have shares here referred to equity or some stake you have in a company, funds with data bank, with some investment organizations. You have monies in bank account. You have copyrighted materials or properties. You have patented materials. All these are properties that you, when you self-acquire them or you acquire them personally, you can put them in your will. Very important. So, having explained that, let's talk briefly about self-acquired properties again. Having mentioned the ones that can be self-acquired or what it means to acquire self-like. Let's identify some of the properties that are generally known to not be personal properties. Okay. And we are talking about family property. Once it's for the family, it's not for you alone. You may have a share in it, but it's not for you alone. So you cannot put it in your will and give all of it to someone else. Okay. Then stool or skin properties. I mean, property belonging to a stool. You cannot, you as an individual, as a chief or a head of family, cannot give it out to your children or your preferred people by your will. Now we talk about companies' properties. I mean, this is a lot of them, right? You cannot give your company's car that they've given you to be driving and using for rounds in your will just because the company asks you to be driving it for the time being or for the duration of your work. You can put it in your will. The properties belonging to a group. I mean, you have a group of friends who are doing some susu, and you buy some land, then you go and put the land, in your will and give it to your wife or your husband or your or preferred person. You can't do that. Again, properties which you are just a caretaker. I mean, if you are taking care of it, it doesn't belong to you personally, so you cannot put it in your will. So there are some of the properties that you cannot put in your will because they do not qualify to be personal properties. So that's our properties that you'll be entitled to at the time of your death. Now, these are category of properties that the individual would take or would be given at the time of his death. So if it's, for example, a contribution you have been making, and the contribution is such that when you are dead, it will be given to you or for the benefit of someone you have nominated. Then once you die, at the time of your death, it is your property. Even though before you die, it's not yours, but once you die, it's yours. Those properties, you can also put them also in your will. And a lot of us also uh, make contributions towards some insurances or uh, insurance covers for protection, warfare, and all of that. Some of these contributions, the benefits only accrue to you at the time of death, so they could form part of these properties. And sometimes properties that you jointly own with others. It could be you and your husband owns a property together. I mean, once you jointly own it and it's clear, you can put your share, because once you die, depending on how you own it, right? If you own it jointly, at the time of your death, your portion is supposed to come to your estate, and that portion can go to your preferred beneficiary. So that is important. Now, briefly, let's talk about properties that you'll be entitled to after death. These are also properties you can put in a will. Uh, they are properties, it could be monies that are payable to you, the testator, at the date later than the date of your death. So, a debt that is payable in the future to you. Maybe someone owes you, the person is supposed to pay by the contract in 2036, but you die in 2030. So 2030 is not yet due. They can't give it to you. But 2036, it is due. They will give it to you. So that money, even though it's yet to be due, you can put it in a will. And when the time is due, it will be yours. Okay, so let's talk about the second leg. So the first leg we talk about is what you can do by will. We talk about the fact that you can dispose of properties, right? We're talking about the second thing you can do by will. That is to determine how specific matters should be handled upon your death. If you are not there, how some things should be handled. You want to also make provision for it, and you are permitted to do that by your will. So let's look at some of them. As I explained, a will can also contain clauses that provide for matters other than disposal of properties. So example could be that you can actually appoint trustees or executors who would have the power to act in your place as a testator and carry out your instructions. If you don't make a will, when you die, no single person will be responsible for protection of your properties until certain people have gone to court and are given authorization to come take care of properties and distribute them. But if you make a will, as soon as you die, from the moment you die, the executors you appointed a will, they have the power to protect the properties before they even go to court to get any documentation. So that is one of the things you can do when you make a will. You can decide who becomes your who becomes your executor, the people who carry your instructions when you are dead. You only do that by will. And then you can also appoint people to be guardian of children who are below the age of 18 years. You can actually make provision for that also in your will. And you can also appoint trustees, like I said. You can set up a whole trust and ask that money be deposited into it from certain bank account of yours and be used for certain purpose, maybe to support the education of the needy, I mean, to take care of certain kinds of disease. I mean, you can always do that. And you appoint trustees who will be in charge of the fund. So you can do that apart from just giving up properties. And then you can also make provision for the care and education of people who are your dependents. If you think that, I mean, you are not able to give them any property, but you want to make arrangement for them, you can set up a fund or an NGO, something, a system can be put in place to solely take care of their welfare when you are not there. So those are some of the things you can do. Then you can also make provision for your debts to be paid. A debt that you yourself you owe, you know that you are supposed to pay by 2030, but unfortunately you could not live till that time. I mean, it has to be paid. So you make provision for it to be paid. There are a lot of other things you can actually do by will, which are not property disposition. So you can actually decide how you are buried. If you want to be buried or cremated, or you want to be sent to a medical facility, you can actually make provision for that as well. Of course, this is also often discussed with the fact that uh, your body is not yours once you are dead. It belongs to your customary family. So they own your body. So if you make a will that your body should be, say, burnt or sent to a medical facility or buried, but the family decides otherwise, what happens? So those are some of the things that, I mean, the lawyers will argue about, but you can make provision for how you want your body to be buried. This is one of the matters you can tell. Then, um, now, when does a will take effect? Let's talk about that briefly, maybe a few minutes. A will is not a legal document with an intention. In other words, if you are alive and somebody finds your will today and go and started doing some things, they cannot even stand on the will and take the properties you have given them in the will because you are still alive. So a will is not a legal document. It doesn't have any legal effect unless the one who makes the will is dead. So once the testator is dead, it becomes a legal document. Anybody can, you know, rely, the intentions now have some force. Okay. So because on a legal document, it need not be prepared by a lawyer. It need not be prepared by a lawyer. So you can prepare your own will if you want to, except that you always will have to have some guidance by a lawyer to know what to put inside, what not to put there. So they don't go and, for example, make a beneficiary a witness and it can create complications for you. So it's not a legal document. If it's not a legal document, what it means is that it does not have any effects once you are alive. But as soon as you are dead, it takes effect after your death. That is very important. Of course, a celebrated case of Beddington versus Berman is the case that Lord Davey stated that a will is an ambulatory document having no force or effect whatever until the death of the gentleman who made a will. So that is a statement of law. It's no document until you die. And of course, this fine expression in the scriptures as well. In Hebrews 9, verse 17, the Bible says that because a will is in force only when somebody has died, it never takes effect while the one who made it is alive or is living. So, I mean, that is how it is. A will only takes effect after your death. So, if you make a will today, so long as you are not dead, it is not anything. You can even change it the next day. You can revoke it. You can say you don't want again. You can cancel it. So don't be discouraged. You can make a will today, and then if you're not comfortable with it, you go and change it, or you go and revoke it and say you'll not make it again. And you can also make it today. Give something to some people and be observing them. If they don't keep up good character, you think, oh, they can no longer manage the property well and all of that. You can go and change the will and then remove them. So it doesn't have any legal effects. It's just a document until you die. Very important. So if you make it now and you happen to die in 2053, it is 2053 to take effect. Okay. Um, I could pause for a few seconds to take a question if there is any before I talk about the implications of not making a will. Is there any question for me briefly before I continue? Any question, please? Okay. There's none in the chat as well. So maybe I can continue. And I believe you are hearing me well enough. Okay. Okay, someone has one in the main chat. So it says, is a will the same as a trust? No, a will is not the same as a trust. A will is a written declaration of your intentions. A trust is a declaration of an appointment of a trustee to manage a property for the benefit of another person. So a trust will always have three important things. A trustee, the people who will manage the property or the subject matter. And then he must also have a subject matter, the thing they will be managing. And then he must also have a beneficiary, the object. Who is this trust going to benefit? Of course, you who is making the trust, the law calls you settlor. And as a settlor, you can also make yourself a beneficiary. So the most important things for a valid trust to exist is the trustee, the subject matter, and the object. What is equally important is what the law calls the intention to make a trust. Can we infer from all of these things that you intended to make a trust? If so, then a trust can also be construed. So, I mean, a trust is different and it's not the same as a will. A trust will take effect whilst you are alive right now. Okay, you to take effect right now. It's a document you sign, and by signing it and registering it, you have appointed certain people as your trustee. They will begin to work. The law has obligations imposed on them to do certain things, render accounts to the beneficiaries, and do all of those things, ensure that the properties are protected and taken good care of. And the beneficiary has the power to, and monitor them. If they fail to do their job, where they can apply to the court for the court to sack them and appoint different people. I mean, all of those things are there. So it's a whole topic on its own, and it's not the same. A will is something that happened, only take effect when you are dead, but trust takes effect whilst you are alive. There are a lot more distinctions, and they are not the same. Okay, any more question, please? I mean, that's a good question. So, um, okay, another question is: are there requirements for a will? And what about a trust? So yeah, there are indeed different requirements, just like I was explaining. A trust has specific requirements of appointing trustees to take care of a property for the benefit of some people. But a will is appoint executors who will distribute, dispose of, give to other people what you have worked for while alive. So, I mean, that's a basic difference. Okay, is there any more question? I wish someone can unmute himself and ask as well if there is any. Okay, I will just continue. Maybe if some comes along, then I will explain it. Okay, so let's talk about the implications of not making a will. Many of us on this call probably have not made a will. So what is the implication? If the Lord calls you home today, is there a question? Okay, I thought I heard a voice. Yeah, that's fine. So, I mean, in as much as not compulsory to make a will, and most people don't actually make a will because they have certain perceptions. So many of us on this call, maybe 90% or 99% have not made a will. And if you die today, a lot of things are going to happen, I should say. So whatever reasons you may have for not making a will, there are implications. Maybe your perception is that if you make a will, it means that you are going to die soon. In fact, I have actually worked on wills, uh, of which there are some disputes. The people who made them actually made them when they were in their 40s and only to die in their 70s and 80s. So sometimes you may not truly die just because you make a will. It may not be true. It is not true. And then also, there are people who have the perception that they don't have enough properties, so they can make a will. When I make a will, what will I, give out to the beneficiaries? I mean, everything of yours can be given out. You don't want your some strangers to come and walk into your husband or you and your husband's bedroom and pack mattresses and bed sheets and send it to their. I mean, everything in your bedroom is property. You can put it in a will. So yeah, those perceptions should not prevent you. So let's talk about some of the implications of not making a will. The first one is that when you don't make a will, automatically there is a law which you have learnt about when you were in secondary school. We all studied social studies. So social studies taught us about P&E's Law 101. So P&E's Law 101 is a law that has certain methods of sharing property of people who refuse to make a will. In other words, the state has made that law to make a will for you if you have not made one. And that law will not, the way it wants to share the properties may not always favor you. That is why, if you want to avoid the automatic application of this law, you make your own will and decide how your properties are shared. Maybe you don't, there is a particular child of yours who you know will not be able to take care of certain properties well for the benefit of the whole family. But if you've not made a will and decide which of them is able to take care of property or is able to, take it and take care of the family, chances are that because he's your child, he'll be qualified to receive benefit from your estate and he'll probably misapply them. So all that some people have actually lived their life on earth, acquired many properties and built wealth for themselves, only to have all of them, get dissipated within years or months after they are dead because certain irresponsible people uh, benefited from the estate and they couldn't take care of the property. So you have the right to know who can take care of properties when you are dead. So when you make a will, you give it to such persons to take care of it. I'm sure we all recall the will that circulated on social media about of Sir John when he gave a lot of his properties to his nephew. Um, so you could tell that he decided that that is a person he wants to give the larger portion of his estate to. Maybe because he knows the guy. The guy was trustworthy enough, and the guy has really demonstrated throughout his lifetime that he can take care of the properties better than even other persons that he may have. So it's important you make a will if you want to avoid the automatic application of the PNDC law. The PNDC law tells you that, so, for example, give 2/3 of all so and so properties to customary successor, give 1/3 to wife, give 3/3 to children. So it tells you, it gives you the formula of how you share it. But if you don't want that formula to be applied, you may not know who these people will be. Customer success may differ. You may not know who they are. So if you want to avoid it, you just take care of your own thing. That's very important. Okay. So another implication also is that you will not be able to choose your own personal representatives. And personal representatives here are people who can act in your absence, who can do things that you want done when you are not alive. If you don't make a will, you are not able to choose them yourself. The law has already chosen them for you. They will be your spouse, your children, your parents, and a customer successor. Those are the person that the law has chosen for you. But if you make a will, you can go and choose your cousin somewhere who is very diligent and very responsible to be your personal representative, who will take care of all your affairs and ensure that people you left behind are well taken care of. So that is important. You can always make a will to ensure that you are able to choose your own representatives. So a testator may, by his will, appoint personal representative of his choice. It is one thing to make plans for who should benefit. It is another thing entirely to nominate persons who carry out your instructions. So you might choose that it should go to my wife, but the one who ensure it goes to your wife, if it's not correct or it's not somebody you choose yourself, there may be problems. Okay, so the testator could freely nominate his personal representative if he dies intestate. The law, of course, prescribes the category of persons who can act as administrators of one's estate, irrespective of deceased disapproval of them. So if you die without a will, the law already provided the people who would act on your behalf, whether you agree they should act on your behalf or not. I mean, you may also belong to a school of thought that says that once you die, you die. So what happens behind you doesn't really matter. But if you care for your loved ones and you want to ensure that they have a comfortable life, then you take care and ensure you have a good plan for them. Another implication, of course, is that personal representative power to act immediately immediately upon death of the testator. So once you die, the personal representative can start to act to protect your property. They can start to act to preserve your assets. And aunties and cousins and nephews begin to jump on them all over and be causing fights in the family, taking people to court and causing division in the family. This is one of the things you get to benefit. Um, when an executor is appointed by will of a deceased person, the executor has the legal authority of death of the testator. He does not need to wait for the probate to issue. So the probate here is a documentation given by the court to take care of it. I must chip in that if someone dies and you use his properties or her properties, thing called a probate, or without being an executor, or without getting another thing they call letters of administration, you actually committed a crime. For 3 years, you can go to prison. So it's important. If your mom is dead, you think it's your mom, so you go and start using, you go start using her, I mean, jewelries and things like that, you are committing a crime. It just so happened that you are not reported to the police yet, but it is a criminal offense to do so. So yes, for those who do not make a will, nobody can act to protect or preserve their properties necessarily unless they go to court for what we call LA, letters of administration. So this is one of the things you avoid. I mean, you don't want properties to be left unattended to or protected. Your cars will be left in a garage and they are getting dirty and rusted. Just waiting for you to be buried and you go to court, there'll be litigation, before they come and take your property. But if you make a will, as soon as you die, the next day, somebody can even drive that, executors can come in and take care of whatever it is that needs to be taken care of and ensure that they preserve the properties for you. Okay, that's important. Okay, so having talked about all the implications, I think the last one, or the second to last one, as you mentioned, is that if you don't make a will, you sort of do not have that positive display of wishes. You miss the opportunity to display your own wishes, to make it known. I mean, you are the one who have toiled and worked for all the cars, the vehicles, the things you've acquired. I mean, you leave them on earth and go, but you have worked for them. Wouldn't you feel more proud if you take control and decide who takes what and what goes to who? Maybe you will be proud to do so. Maybe you wouldn't. Fine. But some people are proud to take control of their estate and decide who takes what. I'm working on a very recent will. I mean, the testator is cheerfully dividing his properties. You know, let this one go to my son, this one to my brother. See that car I've been driving, you give it to my son. I want my daughter to take this one. Oh, my daughter is doing this, so I don't want him to do this. I mean, you have control, you decide it because they are yours, they are properties. So, I mean, that is very important. You don't want to avoid missing the opportunity to express your positive uh, wishes as to what should happen to things you have personally acquired. Okay, so the last one is your inability to appoint people we call testamentary guardians. So these people are only appointed pursuant to the wishes of a testator. So you appoint them in your will without having to go to court and all of that. You just appoint them and they take care of certain people who are unable to take care of themselves. They may be dependents, they may be children below 8 years. You can appoint a guardian for them. I mean, I have certain um, instances where uh, some colleagues have their father or mother being so ill that they can't even take care of themselves. Their bank account is left just like that. Employers are not even minding them, or they are paying a salary or it's going to somebody else's pocket. Properties they have, they've been renting, tenants is being misused. Tenants are becoming the owners of the properties. So in some of those instances, you as a son will now become a guardian to your father so that he can take care of his properties. But it can also happen that before your death, you also appoint somebody as a guardian to take care of certain people who you think may not take care of themselves well or were depending on you while you were alive or are not having the means to take care of themselves when you are dead. So it's important to make a will for some of these reasons, which implications will not come on you should you make a will. Okay, so we are almost getting to the end. That is the end of it. So I believe you pick some lessons from this one. And if you do share a feedback with me. I'll be glad to hear that. And if you have a question, this is the best time to ask or the why or the how or the what or the when. And then we get to answer them if we can. If we cannot, we'll tell you where you find your answers. So please, this is the end of the presentation. Any question for me? Any comments? Any feedback? What have you learned so far? Yeah, so I'm listening. Or should I mention names so that you can tell me what you've learned? Because some people wouldn't talk until you ask them. Once you ask them, realize that they have so much to say. Yes, any question, please? Brad Godwin, Hannah, Jane, any question, please? Yes, Prince has a hand raised up. Prince, please come in.
Thanks for the great presentation. Please, I would want to know, so there's a case where there are a lot of people who may, as you said, there are many people who don't have a will. But then there may also be cases where someone has a will, but then the beneficiaries do not know about it. Is there a process for beneficiaries to find out whether this subject or this person probably already has a will that they might not know about?
Okay. Okay. So yes, there is a way to know whether someone has made a will or not. So let's say the person stays in Accra. That is where he has his place of abode, a place you have stayed for such a long time. And when he dies, you can make searches, right? You can make inquiries at the various courts, the high courts, the circuit court, the district court, within the region where the person has his place of abode. And they will confirm to you whether or not he has a will deposited there. Because when you make a will, you're supposed to keep it at a safe place. And it's not mandated to keep it at the court, but the court has been the place that most people keep it. So it's the best place to go to make inquiry. Some people actually keep theirs at the bank, but I'm yet to come across one like that personally. But some people say they keep it at the bank. So the idea is to keep it at a safe place. So normally, when you want to find out if the person has a will, you do a number of searches at the court. If the court registrar runs through their archives and tell you there's no will of the person, then we assume truthfully that he has not made a will. Then you go for a letter of administration to take care of his estates. So it means the person has actually died intestate, that's without making a will. Yeah, so that is a brief answer. And sometimes when you're not able to appreciate how to go about these searches, you can engage the service of a lawyer who will assist you. They do that best. Yeah. Okay. So I believe I answered you.
Yeah, Laura. So as a quick follow-up,
Yeah.
maybe by way of education to us as well, do you recommend for people to actively communicate to their beneficiaries when they prepare a will? What are
No.
some of the measures to also make sure? And you mentioned some of the fears that people
Yeah.
have. In fact, there are people who are scared that if they let people know that their properties are being willed to them, people are you scared that those
We'll
people
kill them.
will kill them so that they can take over the
Exactly.
properties. What are some reasonable safeguards that people put in place to make sure that, yes, these are fears that people have, we can't do anything about it. How do
Yeah.
you go around that to make sure that there's sufficient communication to their beneficiaries while
Yeah.
also making sure that, I mean, they allay their own fears in this
Yeah.
area?
Yeah. So I mean that's important. Some people cannot just keep their mouth shut. So when they make a will and give something to somebody, the whole community will be aware and the trouble will come. So ideally, um, when you make a will, the beneficiaries need not know the content until you are dead. For your own safety and for your own, security, they did not know. But if you live in a very friendly family where bitterness and all of that is not so high, or you are so sure that if your wife gets to know that you are giving this property to your daughter, she will not change her character and begin to act weird and begin to think this or find a way to poison you. I mean, you will know your people, you understand? So the best way is to not disclose your beneficiaries to people, and do not also disclose the fact of you making a will to people. The people who will get to know you make a will are two witnesses who will come and witness your signature, not the content of the will. So the lawyer who prepares the will for you, if you did not prepare it yourself, and then the two witnesses who come in to sign the signature for you, they will be aware that you have made a will. And the lawyer, of course, he will know everything from inside to outside, and he'll go and deposit for you at the court and all of that. So the best is you yourself do not disclose the beneficiaries to them. Do not tell them that they have, in my will, I gave you this and all of that. I mean, just move on with life as if you've not made a will and just keep it there. I mean, that is just how people go about it. There are instances where we have two people that don't send a draft home to go and revise it at home and bring it back to us, sit in our office and do the draft here. When you are done, we'll take it and make the correction and shred it. But they don't listen. They go, they send it home, and probably their children or wife get to see it and do not approve of the content or how the things were shared, and then trouble starts. So the best thing is that, I mean, do it secretively and get trusted friends to be your witnesses. The executors you are appointing don't know. They only get to know when you die because you have their address there, they have not the contact there, and the lawyer would always help in searching them. If they cannot be found, there's provision in the law to get different people to be appointed as executors for you. So I mean, that is just how to go about it. And of course, there are strict protection within the law for people who disclose content of your will and all of that to other persons. They can be punished for it as well. There are provisions in the law to protect you. So all of those things are there, but the onus lie on you more to ensure that for your own safety, security, and all of that, you keep quiet until you die. Okay. Okay, I believe I did justice to it more. So there are a lot of questions in the chat box. I would like to take them so that we can conclude soon. So can you make an oral will? Yes, you can make an oral will, but this is not for everybody, right? Um, the way we are talking about today is the written will, where you write it and then it is signed and witnessed and go and deposit in the court. There is also a will which is called customary will. Customary will. You are you are under the how do I say? You just had a very strange feeling that you may die, and you are lying on a deathbed. You are so sick. Chances are that you will just die in the next few minutes. So you are laboring under death, and in that circumstances, you invited your children to come closer to you, and in the presence of certain witnesses, you have made known to them that Kofi Mensah, you see that my house there. In case I don't make it, please take it. It is yours forever. You call another person and said, Kofi Menu, you see your uncles are here. I'm telling you this. If I don't make it, please, that coconut farm, take it. It is yours. That oral declaration on a deathbed, the death must be so close, and we will know when it's so close. That oral declaration you make also qualify to be a will, and it's called customary will. In fact, there's a whole lot of discussion we can talk about under that area. So I may not want to talk a lot about it to confuse you here, but I mean, there is an option. But generally, you just have to uh, intentionally make a written will to avoid all the issues that may come with an oral will and all of that, because it's a customary concept, rely on eyewitnesses account. It doesn't have a writing, so it might not be proved by any written document. You just have to rely on the witnesses who will be alive to, I mean, help you get it through. So you can't do that, but the circumstances for doing so are there. And there are also certain people who can also make it. Maybe people who are not who are in the armed forces can also take advantage of that and make certain wills that are not formal, like you writing a will and then giving properties to people and having it witnessed. Okay, the questions are a lot now, and then I see a hand up too. Let me take the next one, then I take the hand. Bragodin, please, a minute. Can a matrimonial property acquired? Let me take up this to see the question well. Can a matrimonial property that is acquired during the pendency of a marriage be willed by one of the spouses? So this is a good one. If you and your wife or husband has acquired a property when you are married, can the husband will that property to you, the wife? The right answer is no. And the right answer is also yes. No, because all of it is not yours. Yes, because the part that is yours can be given to your wife. So if it is jointly acquired and you know that it is a joint property, means you have, presumably you have like 50, your wife to have 50. So when you have your own will, you can only will your 50 to your wife because she already have 50. So she can take only the 50 to add to her own. You cannot give her all the 50. Like you're taking her 50 and give back to her. I mean, it doesn't make sense practically, but it will create confusion when that person does not become a wife at the end of the day, or the time you die, she's no longer a wife. Then there will be trouble because if she's a wife before you die, she will take her share as a wife, as a joint owner, and then come back and take from your estate whatever you have given her from your will. So it is a yes or no, depending on the explanation I just gave. So yes, your joint portion can be given out. No, you cannot give all. So this is what we normally do. We normally, I mean, I've done very recent ones, as recent as today, where we stated that I live in a property described as so and so and so, located at this town. I acquired it with my wife as a matrimonial home. When I am no more, I want all to go to her. So that one you have relinquished your share, and then she takes all of it. That can be done. Okay, that can be done. So technically, and the same way, you cannot give that matrimonial property to a different person other than your wife. That will mean that you can only give your 50% to that other person, not all of it. I believe that is clear enough. Now, what happens to assets which were discovered after a person's death, but not mentioned expressly in the will? So we have something we call letters of administration with will annex. So if I have 5 cars, 2 houses before my death, or maybe during my lifetime, and I put that in my will and give it into beneficiaries, and I made a will in say 2009, and I die in 2030 something or 2050 something. Now, between 2009 to 2030 something that I die, I could acquire new properties, which I may not probably go back and change the will to put inside. If the executor found out that there are other properties which are not in the will, they will apply for LA with will and as they will attach the will to the LA application. It means you die testate, but there are intestate provisions that would apply to some of your estate. And those properties will be treated as properties that will be shared under PNC law. And the ones that are within the will be shared as in accordance with your wishes. So that is how we go about it. Yes, good questions. Do spouses and children have automatic rights to the estate of their parent, regardless of a will stating otherwise? No, they don't have automatic right. If the will says otherwise, that is it. But if the children are below 18 years and they were depending on you, you've not made any provision for them, they can go to court and say the court should look into your estate and see if they can give them something small to sustain them till they become a major. So they can apply for provisions, but they do not have automatic right to the estate of their parent, regardless of what is in a will. So you can actually make a will and give all your properties to one cousin of yours and leave your children and your husband or your wife. You can do so if you want to, it is yours. But I mean, no automatic right. Are wills expensive to make? How much do you charge currently for one? Well, so wills are not very expensive to be made if lawyers are making it for you. The minimum, we have a simple will, complex will, and complicated will. That's how we clarify them. Just to take the fees from you in certain grades. So we have simple will. The minimum you can get for simple will is 5,000 cedis per simple wills. And simple wills, for in my estimation, yeah, those that the person only have one landed property and other properties. So one landed, maybe one plot of land and some few houses. That is a simple will. So you might go for like 5,000 cedis. That includes the professional fee as well as the fee to deposit everything for you. So, but for complex will, you must have at least 2 landed properties, and it can range from 9,000 going. And there can be complicated ones where there are a lot of properties. Some are outside the country, some are within outside jurisdiction where you stay, outside the region where you stay. and it looks a bit complicated. So those ones, a lot of work going through it. So it can be as high as 25,000 cedis. So I mean, it varies, and each factor will determine the fee. It's negotiable. You can always discuss with a lawyer or the person doing it for you to ensure you get the best deal. Do you pay taxes on your inheritance under a will? Yes, you pay taxes. In fact, um, just today I sent someone to Kumashi to go and pay taxes for a will we are probating. So we pay taxes, and it's 3% of the total value of your estate. So you see, all you are working for when the government is taking 3%. That is how it is. They'll put all together, then 3% goes to the government as tax. That is how it is. So you pay tax on it, 3% of the total value of your estate. If your estate value is 1 million, then 3% of 1 million, which I believe is some figure, 33 point something thousand Ghana cedis, goes to the state as estate duty. That's very important. Whether under will or LA, the same estate duty applies. What's the difference? Those who raise their hand, please, I'll be with you shortly. I think time is even up, but let me just take these two questions quickly, then we go. What's the difference between having a next of kin and making a will? Do they serve the same purpose when it comes to inheritance and decision making after death, or they're important distinctions? There are important distinctions. Next of kin, is it terms so that you understand, is simply a contact person. Next of kins don't have any power whatsoever to inherit from you. They will not be called to come and take their funds in your account because in the account opening you call them next of kin. No. They will only call them to make decisions on your behalf if they cannot reach you. They are only contact persons in your absence. They are contact persons in your absence. They are contact persons in your absence. They are not. So people prefer to make their wife or their husband or some responsible brother the next of kin, thinking that that person will inherit whatever, account money is that is in the account after them. But next of kins are just contact persons. Okay, making a will, the people you put in a will are beneficiaries. They are different from next of kins. And you can have a next of kin who will not have any benefits. You can have beneficiaries who have benefits. So they are different things, and they have different purposes. So I believe that answered the question. Next of kins do not have to act only after your death. They can be contacted when you are alive, but you cannot be heard of, or you cannot be found. Or when you are dead and they cannot trace your family, they can contact him so that he can be the contact person to get to you and your family. But for will, it's always after death. After death, it's purely inheritance as well. What is the minimum for doing a trust? Yes, trust is relatively expensive than a will. The minimum you'll get is 7,000, and it varies depending on the things you want to put in the trust deed. If there are many instructions, many duties you want the trustee to perform, too many expectations here and there, then the value would differ. But if you get 7,000, you get a simple trust, which will be probably some 3 or 2 pages. Yeah, but the complicated ones that will have more properties and more responsibility for the trustees may be more expensive. Okay, so please, I believe I've answered your questions. If it's not so clear, unfortunately, time is against us. So you can still re-ask and may clarify some few things. But let me take Godwin and I'll take Sebastian. Then I can hand over to the MC. So please, Godwin, please ask your question if you are still able to.
Hi, good evening. Thank you so much for the insightful teaching. This is very an eye opener.
Thank you. Yeah.
There's this situation I know of. I just want to find out if say you found a will or there's a will that is not signed by the witness, it's a copy. So there's this situation I know of where the original copy of the will, well, it looks like there are some disputes. Later on, a copy of the same will was found, but that one was not signed by the witnesses. Is there a way, is that valid? And is there a way to
have mandatory? It's mandatory. You must always have a witness to your signature. The witness your signature, not the content. So without for what a person dies without a will, what you apply for, if you're applying for it, you can attach that will to it. It might have some effect, but the person will be treated without a will. Yeah, because it must be witnessed by two people, two adults, to have full effect and legality. That's what will come to us. That if you found a will which it's not yours, but the person who made it is dead, what do you do? I mean, you have to lodge it at the nearest and make a report about it, because that is a missing document. So you have to report to the police that you found a missing document. You have deposited at the court. If you don't do so, you will be punished for criminal offense. So, I mean, if you have possession of a will which is not yours and the person is dead, you have to quickly do these two things: that you have found a missing will, deposit it at the nearest court. So yes, I think I answered you somehow. But if there are more personal details about the facts you mentioned, we can talk a bit more extensively after the call. But if you find a will which is signed by the testator but it's not witnessed, it is not good. It is not a good one at all.
Okay, thank you.
You're welcome. Sebastian, yes. So finally, your hand is down. There's also Kingsley. Kingsley, drop it. Sebastian, please ask your question.
Thank you very much for the presentation. I want to find
Sebastian's
out
wife. Yeah. Sorry. Please ask.
I want to find out if you can make a will for unborn children or future children, and also, do you release wills for people who are considered they cannot hold the property or vote? For example, people with mental issues, people not able to, disabilities, and not able to make decisions that a normal adult can make. Yeah, I also wanted to find out if you have a written, not necessarily a will, but a testament, something you write on your own and sign, like an agreement that when you die, this and this and this should be given to that. But it is not, it didn't pass through the courts, or it's not defined as you defined how a will should be signed and all that, but the person wrote it and in his own handwriting and signed. Would that be considered valid as a will?
Okay. Yeah. So
Thank you.
it's yes. Thank you. So to be a yes, if you were a member of the armed forces, you also be considered yes. You can even write on a paper and sign it and date it without a witness. It will be considered valid. But you who is a civilian, yours must be witnessed. So it will not have any effect. It will just probably be seen as a love letter you left behind. But it may play some part when you are applying for the LA. You'll be treated as not making a will, but LA is granted to the administrators, and they have become aware of this document. I think they will be guided by it in how they distribute the property, even though they have to go by the PNC law. So it is not valid, even though it is appearing like something you want to take effect after your death, but it's not valid. Number two, if you have an unborn child, you are pregnant with a baby, and you know that, I mean, you give into that baby, you can go ahead and make a will and give properties to them before they are born. You can do so. And the issues, however, is that you have to be specific with the description of the baby and at the time that they may likely be born, because if, for example, they are born and you are not there, you put some descriptions as to unborn child or a name you want to call that child, and the name is not given to that child the way the people who are alive have given name to the child, then there'll be confusion as to who the child is. So you always have to ensure that you describe it so well. So you can actually go ahead and do that. You can describe that maybe I'm a husband. You say that my wife is pregnant with twins. Confirm, if confirmed, that is it. And I want the 2-bedroom house we have as Spintex to be given to one of them or to be given to two of them as joint owners. You can do that. And the issue about people who are not mentally stable or your properties and all of that other concerns you, that person will own it on behalf of that mentally incapacitated person. So yes, you can give to them, even though you know they are not mentally well. You can give it to them. They will receive it through their next friend. Okay. The same way, children, when you give a house to them or shares to them and they are not able to hold it, the law would construe that they automatically own it by the people they can own things by. It could be their guardian or their next friend, as we call it. So that is what I would say. And that is what it is. I hope it's clear for you enough.
Yes, please. Thank you.
You're welcome. Okay. Thank you so much. I believe I exhausted all the questions and I appreciate all the questions. They really help us to touch on some very interesting areas, especially the ones that were asked by, I think, Brad Dixon. A lot of questions, but very, very practical ones that help us clarify issues. So thank you so much. And there's a lot more on inheritance that we can still talk about aside wills. Wills is just maybe a 2 or 5% of inheritance. So more opportunities will come for us to discuss the other areas. Thank you so much and God bless you. MC, please take over.